Probation violations in Indiana. So for a lot of criminal offenses, if it's your first time or if it's not a high-level offense, some outcomes, whether you take a plea agreement or if you are found guilty at trial, a lot of times you'll be placed on some sort of probation. Now that can either be standard formal probation where you meet with the probation officer a couple times a month, or it could be something more non-reporting probation where maybe you have to check in over the telephone. In any event, being on probation is a suspended sentence. So you have a sentence, but the judge makes it to where you don't have to serve that sentence in, for say, jail. So it's completely suspended to probation. While you're on probation, there's a lot of things that you're going to be responsible for. Some of those can be maintaining contact with your probation officer, letting them know if addresses, phone numbers have changed, letting them know when you're going to be leaving the states, things of that nature. Additionally, while you're on probation, you're not allowed to consume drugs or alcohol. So how does a probation violation happen? Well, basically your probation officer is alleging to the court that you didn't keep up with the terms of your probation. That can be anywhere from failing to maintain contact with them, to something like picking up a new crime, or testing positive for drugs or alcohol while you're on probation. If you're facing a probation violation, there are 3 ways which can resolve that particular violation. You can either come to an agreement with the probation and the state as to how this will play out. You can go open in front of the judge and explain to the judge why you committed that particular violation, and then the judge gets to decide what sort of punishment, if any, he's going to give. Now the third option is setting it for what's called a contested hearing. At that contested hearing, the state has to prove by preponderance of the evidence that you committed that said probation violation. Now preponderance of the evidence is not as high of a standard as proof beyond a reasonable doubt. Basically, the state would have to show to the judge that it was more likely than not that you did in fact violate your terms of probation. Now a lot of times if it's your first violation, if you have an attorney, the attorney can talk to the state and the probation officer and work out some sort of agreement where you continue on probation. However, if you continue to violate for a variety of reasons, the probation officer might recommend to the court that you be revoked from your probation. Now if you're revoked from probation, a few things can happen. The judge can order your entire suspended sentence to be served executed, whether that's in jail, house arrest, or in work release in some instances. Now, a lot of people will come to me and say, Zach, I made it to month 11 of 12 months of probation. I violated in my last month. Why is the court now asking me to go to jail for that entire year? Well, the reason for that being is because your sentence was 1 year and it was completely suspended to probation. You do not get good time credit while you're on probation. So even if you're 1 day away from successfully completing probation, if you violate, you potentially could be looking at that entire suspended sentence to be served in jail, work release, or house arrest. Now, probation violations are not the most uncommon thing in the world. If this is something that's happened to you and you're in need of legal advice, please give us at the Marc Lopez Law Firm phone call 317-632-3642, and always remember, plead the fifth.